Good evening. Global pop superstar Katy Perry is tonight at the centre of a police investigation over bombshell claims of sexual abuse inside a Melbourne nightclub.
There is a moment in every major celebrity scandal when the noise stops and the machinery takes over. The headlines slow down. The social media posts thin out. The talk show jokes stop landing. And what replaces all of that noise is something far more serious, far more methodical, and far more difficult to escape. That moment has now arrived for Katy Perry. What began as a comment on a Threads post about Justin Bieber's Coachella performance has quietly transformed into something that no publicist can spin, no representative can deflect, and no carefully worded Instagram story can dissolve. There is an active criminal investigation happening right now in Melbourne, Australia. A specialist police unit has been assigned to it. A formal report has been filed. And Katy Perry has not said a single word about it herself. To understand why this situation is as serious as it actually is, you have to understand what kind of investigation this really is and what the people running it are actually capable of. The Melbourne Sexual Offences and Child Abuse Investigation Team, known inside Australian law enforcement as SOSIT, is not a standard police division. It was not thrown together in response to a viral moment. It was built over years specifically to handle the most sensitive and complex cases involving sexual misconduct. There are 28 SOSIT locations across the state of Victoria alone. There are approximately 400 detectives working within the system, and every single one of them has gone through a 4-week specialist training program before they are permitted to work a single case. These officers work alongside trauma counselors and forensic experts inside purpose-built facilities called multidisciplinary centers. They use a specific evidence-gathering technique called video and audio recorded evidence, or VAR, to capture witness accounts in a way that holds up inside a courtroom. When people hear that a celebrity is being investigated by police, they often picture paperwork sitting in a drawer somewhere. That is not what is happening here. This is a dedicated, specialist investigation by one of the most well-resourced units of its kind anywhere in the world. And here is the part that makes this situation different from almost every other celebrity scandal that has played out in recent memory. Victoria, the Australian state where this investigation is being conducted, has no statute of limitations on sexual offenses. That is not a technicality. That is not a loophole. It is the law. It means that an alleged incident from August of 2010 can be fully investigated, fully prosecuted, and fully charged in 2026. It can still be charged in 2040. The passage of time does not protect anyone. The fact that 16 years have gone by does not weaken the legal standing of the investigation. If the evidence exists and if the case meets the threshold required by prosecutors, charges can be filed. That is the legal reality that Katy Perry's team is dealing with right now, whether they say so publicly or not. Ruby Rose filed her formal police report at a Melbourne station one day after her public posts went viral on Threads. She later confirmed on the same platform that she had completed all of her statements with detectives and that she had been asked by police not to speak further about the specifics of the case or the individuals involved. She described that instruction as a relief. She said it meant she could finally begin healing. That kind of language, combined with that kind of silence, tells you something important. When someone stops talking publicly about an accusation right after filing a police report, it usually means the system has taken over. It means there are professionals handling the matter now. And it means the process is moving forward whether or not anyone is posting about it online. To understand the full weight of what is now unfolding, you have to go back to how this all started. In April of this year, a music publication shared a graphic on Threads showing Katy Perry making a joke about Justin Bieber's Coachella headlining set. Bieber had performed at the festival the night before and had incorporated old footage of himself as a teenager into the show. Perry made a comment on her Instagram that was light and playful, a small joke about streaming services and YouTube Premium. It was the kind of throwaway post that a pop star makes without thinking twice. But Ruby Rose saw it. And her response was not throwaway at all. She wrote publicly that Katy Perry had sexually mistreated her at a nightclub called Spice Market in Melbourne in the year 2010. Then she kept writing. She laid out a specific, detailed account of what she said happened that night. She described the physical nature of the alleged incident in terms that were graphic and precise. She said she had been in her early 20s when it happened. She said it had taken her nearly 2 decades to say it publicly. She said that fact alone showed how deep the impact of trauma runs. And then she made a move that caught everyone off guard. She dared Katy Perry to sue her. She said she had photographs. She said the event happened in front of witnesses. She said Katy Perry would not take her to court because she knew what had actually happened. Within 2 days of those posts, the investigation was confirmed by police. A Victoria police spokesperson named Sergeant Julian Newman spoke to NBC News and confirmed that the matter was real, that Saucett had been assigned to it, and that the alleged incident took place in 2010 at a licensed venue in Melbourne's Central Business District. She did not confirm any names. She did not need to. The confirmation of the investigation itself told the public everything they needed to know. Now here is where things get genuinely complicated for Katy Perry. Her representative issued a statement in response to the original Threads posts, and that statement was crafted with extraordinary precision. It described the allegations as not only categorically false but also dangerous and reckless lies. It pointed to Ruby Rose's history of making serious public accusations against various individuals and noted that those claims had repeatedly been denied. Read that statement once and it sounds like a standard celebrity denial. Read it twice and it sounds like the opening paragraph of a legal filing. Every word in it was chosen deliberately. The phrase categorically false closes off any partial truth argument. The word reckless assigns a mental state to the accuser. The phrase well-documented history lays the groundwork for a character pattern argument in court. This is not the language of a publicist trying to manage a news cycle. This is the language of a legal strategy being set in motion. And the reason that strategy matters so much is because of how defamation law works in Australia compared to the United States. In America, a public figure who wants to sue for defamation has to prove that the person making the claim acted with actual malice. That is an extremely high bar. Most celebrity defamation suits in American courts fail precisely because of that standard. In Australia, the rules work in reverse. The burden of proof sits with the person who made the statement. If Ruby Rose is sued for defamation in an Australian court, she would have to prove that her account is true. If she cannot prove it to the court's satisfaction, she loses automatically. That legal environment is why Australia has become a jurisdiction of choice for public figures who want to push back against public accusations. Geoffrey Rush pursued a case there and was awarded nearly $3 million. Rebel Wilson pursued a case there and won a substantial payout. The Katy Perry statement reads like it was written by someone who knows exactly how Australian defamation law works and is prepared to use it. But filing a defamation lawsuit carries its own enormous risks for Perry's side, and that risk is exactly why no such lawsuit has been filed yet despite viral posts on Facebook claiming otherwise. No credible news organization has confirmed any legal filing as of the time this was written. The reason a defamation case is dangerous for Perry is the discovery process. Once you file a civil lawsuit, both parties gain access to each other's records. Katy Perry's own communications, her own witnesses, her own documentation from that period would all become potentially discoverable. That is a risk that cuts both ways. The same legal system that places the burden of proof on the accuser also opens the door for the accused to be examined in ways they might not welcome. And then there is the physical venue itself, which contains a twist in this story that has not received nearly enough attention. Spice Market, the nightclub where the alleged incident occurred, closed its doors permanently on the 1st of January 2026. That was exactly 3 months before Ruby Rose posted her account online. The club had operated for over 15 years in the basement of a building on Beanie Lane in Melbourne CBD, right next to the Grand Hyatt on Collins Street. It was a large venue with a capacity of around 600 people and a private VIP section called the Genie Bottle where celebrities spent most of their time. When police opened their investigation in April, the club was already gone. The ownership had scattered. Staff records were almost certainly no longer organized in any central location. And any surveillance footage from August of 2010 had been deleted decades ago, because Australian nightclubs in that era typically retained security footage for no more than 30 days. The physical evidence trail from that night is almost entirely cold. What remains is witness memory and whatever private documentation Ruby Rose says she has preserved. The former manager of the venue did speak publicly about the night in question. He confirmed that both Katy Perry and Ruby Rose were at the club together. He confirmed they were in the Genie Bottle VIP area. He confirmed they had been drinking. He said his team arranged a private car and driver to take both women out through a back fire exit in order to avoid photographers. He said he believed they were taken to another Melbourne venue called the Peel Hotel after leaving. And then he said something that lawyers on both sides will have noted carefully. He said he was not aware of any alleged misconduct. He said he was not aware of anyone vomiting. Those sentences do not deny the event. They specifically state only what he personally witnessed and knew. That is an extremely precise kind of answer, the kind of answer you give when you have been counseled on what to say and what not to say. The complicating factor at the heart of this case is a column that Ruby Rose herself wrote for a major Australian publication back in 2011. In that column, she described the night at Spice Market. But she described it as a funny story about falling off the wagon after 30 days of sobriety. She wrote about having one drink that turned into many. She wrote about vomiting on Katy Perry's foot. She framed the entire experience as a cautionary tale about drinking too much. She did not describe any misconduct. She did not describe any violation. She presented the night as embarrassing and comedic. That column resurfaced within hours of her Threads posts going viral. Critics pointed to it as proof that her current account was fabricated. Her supporters argued that it proved the opposite, that she had been so deeply affected that she turned the experience into a joke because she did not know how else to process it publicly. Ruby Rose addressed the gap directly. She said she had deliberately reframed the story as a funny anecdote because she did not know how to speak the truth of what had happened. She said that Katy Perry had later helped her obtain a visa to work in the United States, and that she had kept silent partly because of that help and the power it represented. Researchers who study survivor disclosure have documented this pattern extensively. A study published in 2019 found that male survivors of childhood sexual misconduct waited an average of 21 years before telling anyone. Broader research has consistently shown that the majority of adult survivors do not disclose their experiences within the first 5 years. The presence of a power imbalance between the person making the accusation and the person being accused is one of the strongest predictors of prolonged silence. Ruby Rose's explanation fits that documented pattern precisely. But in a courtroom, a written account from 2011 that directly contradicts a current accusation is powerful evidence for the defense regardless of the psychological explanation behind it. The people who can move this case forward or close it down entirely form a small circle. Ruby Rose says she has photographs from that night. She has not released them. If she presents them to Saucet and they can be authenticated and timestamped, they change the evidentiary picture significantly. The people who were present that evening, the hair and makeup artist who was with Katy Perry, the male friend who was with Ruby Rose, the driver who took them from the club, the staff at the venue they reportedly visited afterward, each of those individuals may already be receiving contact from detectives. Their recollections of a night 16 years ago could determine whether this investigation results in a brief being sent to the Office of Public Prosecutions or whether the case is quietly closed. The prosecutors in Victoria, not the police, are the ones who decide whether formal charges are ever filed. Their threshold is whether there is a reasonable prospect of conviction. That is the bar this case has to clear. There is also the matter of extradition. Australia and the United States share an extradition treaty that covers sexual offenses. If charges were ever formally filed against a person in Australia who resided in the United States, the process of requesting their return to face those charges would be available to Australian authorities. It would not be fast. Similar cases involving Australian citizens overseas have taken years to resolve. But the mechanism exists. And given that Victoria has no statute of limitations, there is no urgency forcing prosecutors to rush. They can build the case carefully over months or years if they choose to. What makes this moment in the story so significant is not just the investigation itself. It is the pattern that the investigation has forced back into public view. Multiple individuals have made public statements over the years describing uncomfortable encounters with Katy Perry. Some were made in a joking context. Some were made in posts that were later deleted. None of them resulted in legal consequences at the time. But the Ruby Rose posts have pulled every one of those accounts back into the conversation simultaneously. And when you line them up side by side, a consistent thread runs through all of them. Every account involves a public setting. Every account involves a moment that was framed as playful or joking. Every account involves a person who held less power or status than Perry at the time. And in every case, Perry never responded personally. Her team issued denials or said nothing at all. That pattern is now part of the public record in a way it has never been before. And the investigation in Melbourne is running in the background of all of it, moving at its own pace, guided by its own evidence and its own legal standards, entirely indifferent to what is trending online. Katy Perry has a world tour running. She has a new public relationship. She has a team of lawyers and representatives working to contain the damage. But she has not said a single word herself. Not about the investigation. Not about the accusation. Not about the witnesses. Not about the venue. Only a song cover on Instagram with the words "I love you" and a lyric about truth that her fans debated for days. That silence, held this long, in the middle of an active criminal investigation, is the loudest thing she has said since this began.